and welcome to the daily newspaper analysis, which is brought to you by LawSikho. So today we have one editorial for a discussion that talks about the future of data protection laws in the country. Though we have discussed it earlier several times as well, so we'll quickly take it up. We also have news update and legal news for the day. And please pardon me for my coarse voice, guys. I have a little sore throat, so please bear with me through the session. So when we talk about the data protection bill, as we recently know that the personal data protection bill that was debated for a long time now has been taken down from parliamentary discussions. So there was a huge amount of effort that had been put into the personal data protection bill, and the withdrawal of the same came as a surprise. So a committee that was chaired by a former Supreme Court judge and four other government officials proposed the guidelines of the law back in 2017-18, and the name of the committee was Justice B.N. Sri Krishna Committee that had actually proposed having the personal data protection bill. So one way to understand this decision is to go back to the genesis of this law, which arose out of Justice K.S. Puttaswamy versus Union of India case, which we all know is the most important case when it comes to having right to privacy as under one of the fundamental rights. So in this case, where the court held that the right to privacy had both a positive and a negative aspect. Now, the former implies the need for the state to actively take measures to protect an individual's privacy at large. Now, the importance of the digital economy and its broad scope has contributed to the context of the law. By this, we mean that we all need to have something through which we can, save and protect the entire digital economy, and that we understand the importance of digital economy in today's time. Domestic industries would have faced compliance hurdles under the personal data protection bill that we had earlier, but there would also have been a regulatory certainty. Now, meanwhile, we move forward with this discussion. Please consider that we still had the personal data protection thing as a bill. It was still contested and debated in the parliament, and we did not have it as an act. So please do not have this confusion. That is why we call it as the PDPB, that is the Personal Data Protection Bill. So the bill had issues of intrusive measures that were not individual friendly, and that is why some reasons definitely have been quoted for bringing down the bill. But in this time, we also need to be sure as of if we are going to have another bill that would be a replacement or a substitute to the current bill that was taken down, it should be wholesome in nature and should be capable enough of sufficing all the requirements to protect the digital economy as well as the personal privacy laws as well. So, from being the centerpiece of the legislation, privacy protection was increasingly being seen as one of the several objectives being pursued. Then there was this joint parliamentary committee that recommended moving away from a personal data protection law towards a law to govern the entire data ecosystem. So basically, this joint parliamentary committee was of the opinion that the personal data protection bill was quite narrow and it had a narrower scope. And that is why it was important for us to have a legislation that could cover and protect the entire data ecosystem in the country. So this attempt to solve multiple problems in the digital ecosystem saw an already broad law being turned into an omnibus bill. So the new law that was referred to while withdrawing the bill shall have to deal with the two issues. That is, first, the form of the law and the nature of the protections it will offer. Because of course, if we are replacing it and we're bringing it in replacement of some other bill that was so much under discussion, it should be wholesome and something that has all the elements that are required in this direction. So regarding the form, the government has stated that it will introduce multiple legislations that shall give way to new framework and that would make it more wholesome in nature. And it is healthy to maintain some polycentricity in the governance of a complex digital economy, and different laws and agencies should coexist altogether. So the second issue that we were going to face is that what shall be the nature of privacy protection of individuals provided by the new law? Because, for us, even right to privacy as a fundamental right is a new concept. It is a very concept that has been developed very lately. And that is why how are we going to suffice this or put it under the ambit of the new data protection bill will be definitely a question to be pondered upon. So the 2018 drafts borrowed heavily from the European General Data Protection Rules that are very, very important and widely adopted, especially in the European Union. Thirdly, it should build a risk-based approach to data protection rather than blanket regulatory observations. And that is why the decisions should be taken rather intricately and not just blanket bans should be put upon various things. So based on risk assessments, the law could enable co-regulation and self-regulation with regular acting as a backstop as well. And finally, it is important that any new law is framed based on transparent and meaningful consultations with all stakeholders. Let's see what do we have for news updates today. Firstly, the NHPC, that is the National Hydropower Corporation, inks pact to develop Nepal hydropower plant left by China. So Nepal has signed a pact with the Indian company NHPC to develop a hydroelectric plant in the west of the nation years after a Chinese firm had backed out from developing the same. Secondly, the Reserve Bank of India cancels license of Deccan Urban Cooperative Bank. So the Reserve Bank of India has cancelled the license of Deccan Urban Cooperative Bank in Karnataka. RBI took the decision as the lender did not have adequate capital and earning prospects for the same to be done. Thirdly, first Indian to play in the UEFA Women's Championship League. So, in a proud moment for India, young striker Manisha Kalyan became the first Indian footballer to play at the UEFA Women's Champions League when she made her debut for Apollon Ladies FC in the European club competition in Ingome, Cyprus. Fourthly, Maharashtra declares Dahi Handi an official sport. So, Chief Minister Eknath Shinde announced that Handi will be recognized as an official sport in Maharashtra. The state is set to organize a pro Dahi Handi competition. The Maharashtra government also announced that the Govindas will get a job under the sports category, and if any Govinda lost his life insurance for rupees 10 lakh will be given to his family. So definitely, it's going to be a great exciting spot for the state of Maharashtra. Let's see what do we have for legal updates today. Rape convicts' advanced age and regular attendance in court are no reason for lesser sentence than minimum punishment under the law. This has been held by the Bombay High Court. So the man was convicted for the rape of his deaf and dumb sister, which is actually very appalling. The High Court in the said case held that mere advanced age and regular presence in front of the court could not be a reason for a lesser sentence than what has been prescribed as the minimum sentence under the law. The name for the same case has not been prescribed or mentioned on any of the live law or bar bench websites. If in case we get to know this, we'll definitely update you guys. Thank you so much everyone for staying tuned with us. If you wish to download the PDF of today's slides, you can join our Telegram channel. The link to the channel is there in the description box below, or you can also scan this QR code that you can see on the screens right now. Thank you so much.